Let me first thank the Senator from Oregon for his remarks. He has brought great passion for this issue to the Senate. He serves with distinction on the Banking Committee, and I could not agree with him more that the spectacle of colleagues scampering up to Wall Street to offer their services there at interfering with, obstructing, watering down, and impeding of all things financial regulatory reform, after all we have been through, is not a spectacle that is salutary. And I appreciate his remarks on that. Madam President, may I ask unanimous consent that Jordan DiMaggio and David Williams of Senator Bingham's office be given the privileges of the floor for today, April 20, 2010.
Without objection, so ordered.
It has now become Mr. President. So, Mr. President, I'd like to talk for a minute about nominations and holds. The Senate's executive calendar contains the names of those individuals whom President Obama has nominated to serve in his administration when those positions require Senate confirmation. The executive calendar also contains the names of those the President has nominated to be federal judges. It's called the executive calendar, but judges, judicial offices are on it as well, at both the district court level and the appellate level. Since President Obama took office last year, this Senate has voted on 44 nominees. Some others have been approved by unanimous consent, but we've had 44 votes on nominations. Of those 44 votes, 31 of them, that's 70% of the nominees we've confirmed, have been held over, they have been filibustered, they have been delayed by days and weeks and months. The average length of time that these nominations have languished in the Senate has been over 106 days. That is 15 weeks, 3.5 months from the time they were nominated to the time they were confirmed. And that's just the average delay. Some have spent a full year in Senate limbo as the result of holds by our colleagues. So if it's taken this long to confirm them, these must have been controversial nominees. These must have been tough votes, close votes for the Senate, one would think. Well, let's take a look. And bearing in mind that it takes 51 votes to be confirmed by the Senate. 16 of these nominees that have been held over or filibustered or delayed were subsequently approved when they came to a vote by more than 90 votes in the Senate. 16 of the filibustered nominees passed the Senate with votes more than 90. Another 10 have been approved with more than 80 votes. Bear in mind that it only takes 51 to get confirmed. More than 80 votes, another 10. 3 more with more than 70 votes. That is 29 out of those 31 nominees who, when they finally came to their vote, were approved overwhelmingly by enormous majorities, bipartisan majorities in the Senate. And they had spent 106.6 days on average waiting to be confirmed by those vast majorities, waiting to be confirmed overwhelmingly. So the only conclusion that a rational mind can draw from this is that this is not about controversial nominees. This is about politics, plain and simple, bare-knuckled politics of obstruction. The kind of politics that says, I don't care if you're qualified for the job you are nominated for. I don't care that the Department of State or the Department of Homeland Security needs you for a critical job. I don't care. You are going to sit on the Senate calendar for months and months and months so I can score political points against the president, so that I can inhibit the deployment of this elected president's administration into the offices of government. Well, that is wrong, and it needs to stop. As of Monday, the executive calendar contained the names of 101 nominees, 101 individuals for critical jobs in agencies all across the government that are now sitting on the Senate's executive calendar, waiting. I would like to address some of the judges who have been waiting for a long time, and I would like to ask that their nominations be called up and approved. Mr. President, I'll start with Judge Albert Diaz and Judge James Wynn, who are a pair of judges on the Fourth Circuit Court of Appeals, nominees. Mr. President, I call up executive calendar numbers 656 and 657, the nominations of Judge Albert Diaz and Judge James Wynn to the United States Court of Appeals for the Fourth Circuit. Let me tell you who they are. Judge Albert Diaz currently serves on North Carolina's Special Superior Court for complex business cases. He was reported out of the Judiciary Committee on January 28, 2010, by a vote of 19-0. He has served in the Marine Corps. He has 9 years of state court judicial experience. Judge James Wynn was reported out of the Judiciary Committee the same day, January 28, 2010, by a vote of 18-1. He currently sits on the North Carolina Court of Appeals, the state's intermediate appellate court. He is a certified military trial judge and a captain in the United States Navy Reserves. Mr. President, I ask unanimous consent that the Senate proceed to executive session, and notwithstanding Rule 22, the Senate proceed to executive calendar numbers 656 and 657, that the nominations be confirmed en bloc, that the motions to reconsider be laid upon the table en bloc, that any statements relating to the nominations appear at the appropriate place in the record as if read, and that the President be immediately notified of the Senate's action. Mr. President, a unanimous consent request is pending. I ask for regular order. Request pending right now, and there is no one on the floor to answer it or object to it.
Is there objection?
I'll hold a moment. I'm told that there is a senator who is coming to make an objection. Let me just reiterate, while we're waiting for a Republican senator to come and object to these nominees, that they came out of the Judiciary Committee back in January, that they were voted out of the Judiciary Committee by a, in one case, unanimous bipartisan vote of 19-0. I'm informed that the senator from Arizona, Senator Kyle, is coming to object. He sits on the Judiciary Committee. He likely was one of those 19 that voted in favor of this nominee at the committee level. I don't know who the one vote was for Judge Wynn, who the one vote against him was, but he cleared the Judiciary Committee by a vote of 18-1. Again, a strong bipartisan vote of support. And yet, I'm informed by the floor staff that they're finding somebody to come and object to these nominees, who've now been held through all of February, through all of March, through half of April, despite being, in one case, unanimous votes in the Judiciary Committee, and the other an 18-1 overwhelming bipartisan majority. I'm ready to go. For the record, I am informed that the minority was aware that I was coming to make these unanimous consent requests, that they had full knowledge that this was going to come, and if they are unable to get somebody to the floor to object, that is, as far as I'm concerned, not my concern.
Is
Mr.
there
President,
objection?
I would renew my unanimous consent request now that there is a senator from the minority party on the floor.
Is there objection to the senator from Rhode Island's request for a unanimous consent?
Mr. President, reserving the right to object, might I ask my colleague to restate the request?
Absolutely. The request is to call up executive calendar numbers 656 and 657, which are the nominations of Judge Albert Diaz and Judge James Wynn to the United States Court of Appeals for the Fourth Circuit. As the distinguished senator from Arizona will recall, since he sits with me on the Judiciary Committee, Judge Albert Diaz was voted out of the Judiciary Committee by a vote of 19-0 back on January 28, 2010. If my math is correct, that means that the distinguished senator from Arizona voted for this nominee in the Judiciary Committee. Judge James Wynn was reported out the same day, January 28th, by a vote of 18-1. I do not know if the distinguished senator was the single dissenting vote in this overwhelming vote in support of Judge Wynn's nomination. Judge Diaz has served in the Marine Corps. He has 9 years of state court judicial experience. Judge Wynn is a certified military trial judge and a captain in the United States Navy Reserves. And I ask unanimous consent that the Senate proceed to executive session. And notwithstanding Rule 22, the Senate proceed to those executive calendar numbers 656 and 657, that the nominations be confirmed in block, that the motions to reconsider be laid upon the table in block, that any statements relating to the nominations appear at the appropriate place in the record as if read, and the President be immediately notified of the Senate's action.
Thank you, Mr. President. I appreciate my colleague restating the objection, just reserving the right to object, and I will object. As I think my colleagues are aware, the two leaders have worked out a process for consideration of at least some of the judicial nominations. My understanding is that there is another agreement on at least one and maybe two circuit court nominations that they are working out time agreements on right now that would occur, I presume, later this week. And I think it's important to let the two leaders work those agreements out, as a result of which, reluctantly, I will have to object to my colleague's request.
Objection is heard.
Mr. President, I appreciate the distinguished senator's objection. We do have 101 names, nominees on the executive calendar. The objections and holds, which are secret, are holding people up, as I said, for an average of 106 days. So while it is nice that one or two might be given a time agreement by the minority party, it does very little to relieve the blockade that the minority party is engaged in of judicial and executive nominees. So I will continue forward, and I will call up executive calendar number 701. The nomination of Nancy Freudenthal to be a judge for the United States District Court for the District of Wyoming. She passed out of the committee by voice vote. A voice vote, as the presiding officer knows, is a vote without dissent. On February 11th, 2010, She has decades of experience as a public servant and as a lawyer in private practice. She currently is Wyoming's First Lady. If confirmed, she will be that state's first female federal judge. It is the practice of the Judiciary Committee not to put forward judges unless the consent of the home senators has been obtained, and I would point out that both of the senators from Wyoming are Republicans. Mr. President, I ask unanimous consent that the Senate proceed to executive session, and notwithstanding Rule 22, the Senate proceed to executive calendar number 701, the nomination of Nancy Freudenthal, that the nomination be confirmed and the motion to reconsider be laid upon the table, that any statements relating to the nomination appear at the appropriate place in the record as if read, and that the President be immediately notified of the Senate's action.
Is there objection?
Mr. President, for the same reasons noted earlier, I object.
Objection is heard.
Mr. President, I will now call up executive calendar number 702. It's the nomination of Judge D. Price Marshall to serve on the United States District Court for the Eastern District of Arkansas. A district court decision has been held, nominee has been held and filibustered. This district court nominee, Judge Marshall, is currently a judge on the Arkansas Court of Appeals. He spent 15 years in private practice in Jonesboro, Arkansas. He served as a law clerk to Seventh Circuit Judge Richard S. Arnold. Judge Marshall was reported out of the Judiciary Committee on February 11, 2010, by voice vote and without dissent. He is held and blockaded on this floor. Mr. President, I ask unanimous consent that the Senate proceed to executive session, and notwithstanding Rule 22, the Senate proceed to executive calendar number 702, that the nomination be confirmed and the motion to reconsider be laid upon the table, that any statements relating to the nomination appear at the appropriate place in the record as if read, and that the President be immediately notified of the Senate's action.
Is there objection?
Mr. President, I object.
Objection is heard.
Mr. President, let's try another one. I will call up executive calendar number 704. This is the nomination of Judge Timothy Black. Again, a district court nominee, a local trial court nominee, to serve on the United States District Court for the Southern District of Ohio. Judge Black has served the Southern District of Ohio for 6 years as a federal magistrate judge. He is currently a federal magistrate judge in the court for which he's nominated as district judge. Before that, he spent a decade as a municipal court judge and had a long career as a civil litigator. He was reported out of the Judiciary Committee without dissent after a voice vote on February 11th of this year. February, March, April, more than 2 months ago, he has languished on the Senate floor after clearing the committee without dissent. A district judge, a trial judge who serves now as the magistrate judge. Mr. President, I ask unanimous consent that the Senate proceed to executive session, and notwithstanding Rule 22, the Senate proceed to executive calendar number 704, the nomination of Judge Timothy Black. That the nomination be confirmed and the motion to reconsider be laid upon the table, that any statements relating to the nomination appear at the appropriate place in the record as if read, and that the President be immediately notified of the Senate's action.
Is there objection?
Mr. President, for the same reasons stated before, I object.